I frequently will write a letter or send an email, gee, will you guys decide on one forum? And, it has happened more than once where you write that email or you write that letter and the plaintiffs talk to each other and they decide, yes, we'll go forward in Delaware or yes, we'll go forward in California. And if that happens, it's sort of problem solved. If it's not the forum that you as a defendant would have preferred, it may not be an ideal solution, but at least you avoid the worst of all worlds, which is simultaneous injunctions in two different forums. I mean, no defendant wants that ever, and everybody agrees it's bad. What we're here talking about is how do you avoid that?
Right. So some dreams come true. Others, I don't think are going to come true.
All right. So you talked about kind of informally contacting the various plaintiffs' counsel to try and encourage cooperation. Can you share a little bit more about the dynamic and things that you do to persuade some folks to move to one jurisdiction or other folks to move to another, or to find a way through the maze short of actually having to file a motion?
Sure. So then the hardest thing for the defendant's bar is, do we want to, there's basically three alternatives, and they're not mutually exclusive. Ultimately, the sort of ultimate ways to get litigation in one forum, you could move to dismiss or stay one of the competing, or if sometimes you got three, so you got to move to dismiss or stay two of the three competing forums. You can do a one forum motion, which we'll talk about in a few minutes, or you can do what I call changing the facts on the ground, and that is going forward, agreeing to expedition in one forum, resisting it in the other forums, and events have a way of taking over sometimes, and you wind up with a preliminary injunction scheduled in Forum A, typically Delaware, but not always. Expedited discovery is going forward, and then Forum B and or Forum C, people are fighting about jurisdiction motions and whether there should be expedition, and things just get ahead in the preferred forum. Now, the problem with that is it's a little bit of a dangerous strategy, because you as a defendant will be accused of forum shopping. And I'll get to you in a minute, Randy. And so you'll get the argument, well, gee, if the defendants love Delaware, there must be something wrong with it. So that's the danger. Yes, sir.
Have you actually seen competing PI motions? Because most of the judges, both the Delaware judges and the out-of-state judges that I know, they ask that question. And I have not yet seen one judge in Texas or even a Delaware judge where there's been a ruling, for example, in ACS where we had rulings from the Texas judge. The chancellor didn't, or the vice chancellor didn't say, well, I'm going to go and repeat those rulings and going to do it. So this question about competing motions and competing PI motions, I haven't seen it. Have you?
Well, I mean, you just mentioned ACS, which you were in and I was in, and there were competing motions. Now they got...
There weren't competing here. There were people that were coordinating discovery, but was the same motion ever made in two different courts?
The same motion in that case was made in the same court. As you remember, there was ultimately, it's very unique, there was a combined hearing with the Texas judge and the Delaware judge and counsel, Texas and Delaware, all on the line together. And what they decided to do in that case is some issues would be heard in Texas and some issues would be heard in Delaware. So there was there was no complete conflict in the sense that, gee, we're both going to be ruling on the disclosure aspects or we're both going to be ruling on the deal protection aspects, but there were two simultaneous injunctions in two different forums for the same deal. I don't think anybody would agree that that's an ideal way to litigate. It worked in that case, and it sort of was a compromise. I think it was less than a perfect compromise, but it worked out. But sure, there have been other cases where people have gone at least pretty far down the road.
To my recollection, Atheros, the acquisition by Qualcomm, resulted in a PI hearing in Delaware where an injunction was granted on disclosure issues. There was also a PI hearing in federal court in California. Ultimately, the judge found that the same issues that had been raised in federal court were effectively already being litigated in Delaware. So after the hearing, the decision was to stay that aspect of the case, but the parties had to go through 2 PI hearings, 2 sets of briefing in 2 jurisdictions across the country.
Yeah, but I think to Randy's point is that this fear that the defense bar always likes to raise to the judiciary of like you're going to have 2 conflicting orders has never actually come to fruition.
Well, that's because we settle the cases.
Exactly. Which is another part of the fear,
Well, I
obviously.
think that's because you finally resolve and cure the problems you had. That's why you settle them. You're not going to have duplicative injunctive relief if you don't have problems. That's also a reality. But I think after motions to expedite, which I have seen duplicative motions to expedite proceedings, discovery, even then you have seen the plaintiffs coordinate the discovery. So I think this fear that, look, I give you guys credit, you're trying to minimize the risks. It makes sense, but I don't think that fear really exists. We haven't seen duplicative actual PI orders, and even when you have seen duplicative motions to expedite granted, you do see the plaintiff coordinate efforts. I don't think I've ever heard of both jurisdictions, let's say California and Delaware, granting expedite discovery, depositions go on, and the defendants having to produce the witness twice in 2 different dates to 2 different groups. I think what I've seen is the plaintiffs get together, either they flip a coin who starts first or who goes second, or they take turns, but it is coordinated. So I don't think that big fear.
But here's the problem. So I get a very marginal motion to expedite on a marginal disclosure claim, for example, and maybe there's completely standard deal protection devices that I know a Delaware judge probably isn't going to grant a motion to expedite. But then I've got a second motion to expedite in maybe a less sophisticated forum. Do I go and oppose a motion to expedite in Delaware? Because I might win that, and it might turn out to be a very Pyrrhic victory, because the Delaware judge will say, yeah, these are terrible disclosure claims, and they're completely standard deal protection devices. This isn't the type of thing where I would even schedule an injunction. But a judge who's never seen a deal protection device before says, what do you mean you're going to pay 3% if somebody comes along and offers a better deal? That doesn't sound right. And so then I wind up with a motion to expedite maybe getting granted in that other forum. And so what that leads to sometimes
Reverse
is,
forum shopping.
yeah, it's a form of forum shopping, but it's not that the defendants say, oh, gee, I can't wait to litigate this issue in Delaware. What they're really saying is it's almost like a prisoner's dilemma. I don't think this ought to be litigated at all, and I think that I could probably resist it successfully in Delaware, but that might be a worse outcome, and so I might agree to Delaware because at least if I have to litigate it, it's a better forum. And that happens all the time.
Yeah, but I think the point I'm making is it's not the plaintiff bar causing this problem. Sometimes the defendants are aiding in that problem. You guys are not exempt from this issue. That's the point. And quite frankly, look, we file all our cases in Delaware. We like Delaware, but I understand not everyone has to share in that, and I respect that. But I think if you think it's a weak case, then just saying, well, we're going to agree to expedite it in Delaware, and then we'll beat them at a preliminary injunction because we're afraid what's going to happen in the other jurisdiction. You're sort of like essentially trying to decide where to proceed with your case because, but you're helping the multi-forum problem as opposed to you could just say, you know what, we're going to fight in both jurisdictions.
Well, and we sometimes do that.
I don't think I've seen that.
Well, guys, enjoyable as this is for me, because we're going to run out of time, let me move on. Let me move you on a little, Ken, to actually, we've talked about the things that you can do to set the stage, but let's talk about actual motions to stay, one forum motions, things of that sort. What are the options available to defendants, and when do you choose to exercise them?
Sure. So it's really the three I outlined before. It's a motion to stay, it's a one-forum motion, and then sort of changing the facts on the ground is usually coupled with a motion to stay in the perceived less desirable forum. Look, Lyndon Johnson said a long time ago, never tell a guy to go to hell unless you're prepared to send him there. And a motion to stay can be like that. There are certainly judges who say, oh, great, motion to stay, something off my docket, cool, granted. But there are other judges who are going to get offended by that. Well, you know, what do you mean you don't want to be in my court? You know, and they might take it personally. And they might deny the motion, and you might be back in front of them. And so that's the danger. But I think as a defendant, what you try to do is you try to be as principled as you can about it. And I think honesty and candor helps. So, you know, if I've got, and this actually happened, this is the facts of a real case. I've got multiple plaintiffs. Some of them own a huge number of shares. One forum, the one where the big stockholders happen to be, was filed first. There have already been proceedings in that case. It's sort of like the facts on the ground have changed a little bit. And there's really very little to commend Forum 2. Forum 1, there's a lot to commend it. So what do? Well, you move to stay in Forum 2, and you say that, look, Forum 1, sort of all the things line up for Forum 1. Now, that case happened to be one involving Carl Icahn and Exo Communications. Forum 2 in that case happened to be Delaware. It so happened that litigation was first filed in New York. It had been pending for a long time because there were derivative claims before there was a merger announced. The large stockholders were there. So we went and moved to stay in Delaware over the vehement objection of some Delaware lawyers. But the motion to stay in favor of New York was granted. It could turn out the other way. Where it's hard is where there's no one forum that's clearly the superior forum. You might have the larger stockholder in Forum 1, but Forum 2 maybe was first filed. Maybe there are 4 people who are all coordinated in Forum 2, but the largest stockholders in Forum 1. You know, maybe it's Delaware law, so Delaware has that going for it. But there may be countervailing factors. There may be specific New York or California statutes that might be invoked for part of the claim. That's where it gets complicated, and that's where there's a lot of judgment, frankly, involved. The last thing that I guess I'll talk about is the one forum motion. It's the beauty of the one forum motion is that it's highly principled. You go into both courts simultaneously and you say, you know what, we've been sued twice on the same claim, 2 different forums. We all agree that shouldn't happen. So judges, would you all coordinate with each other and pick a forum, any forum, and let's just do this once. Like I said, it's highly principled. You can't be accused of forum shopping. The downsides are a couple, though. The number one is that, you know, as a defendant, you might actually prefer one forum to another, and that's legitimate. You know, you're allowed to forum shop. Plaintiffs do it all the time. Every time plaintiffs bring a lawsuit, they are forum shopping. They are choosing a forum for a reason. Defendants can say, well, we prefer forum X, you know, for whatever reason, and that's perfectly legitimate. So you might lose out on that. The other thing is courts sometimes say, you're dumping the problem in my lap. You know, why don't you move to stay if you think you got a valid motion to stay? And I guess the last downside is a lot of judges, I mean, Delaware judges have seen one forum motions lots of times, but a lot of judges are going to look at this, and they've been a judge for, you know, 15 years. They've never seen this before. And they, what is this? You know, I'm supposed to pick up the phone and talk to somebody in another state? I never heard of that.